and we've got an action-packed seminar today. We've got a lot to cover, so let's get started. We got Suzana on the line and Jordan on the line. And,
good morning, everyone.
As I say, just everyone else mute your videos to keep the feed clean. All right, let's start with a couple of things. One of the things we wanted to talk about is from a practice standpoint. We always try to keep this focused on our day-to-day practice and practice management aspects of will drafting, is some tools that we're using day-to-day, some technology tools. And I just, and maybe Suzana, you can give some of your initial thoughts as well on this. We're using a couple of tools right now that has really helped us. All of us have our own teams that we have to keep organized to whatever extent it is, our assistants and so on, right down to juniors if they're involved too. And that's a big struggle in this new environment. And then quite frankly, it's going to be a big struggle going forward, because no doubt in many respects, our practices are going to have changed forever. And meaning that we're going to have much more remote access and many more opportunities to work from outside the office. So one of the tools we've brought in, and we brought it in right as soon as COVID started, was a tool called Slack. And another tool that we're using is Monday.com. And I just wanted to spend a couple of minutes on that to show you some of because Jordy, of course, one of the struggles is, and if everyone could mute, please, we're getting a little bit of background and it's sort of going to hurt the feed. So just make sure you're muting your feeds. One of the things, of course, Jordy, is difficult, and Suzana, is to keep our file loads managed. And we have used, as I say, I'm going to show you in a minute a bit about Slack and Monday.com. But why don't you tell us a little bit, Jordy, first of all, some of the methodologies you're using to help move a file along, which is crucial.
So that takes, I used to use Outlook's, the tasks in Microsoft Outlook. And basically what I did is speaking from a sort of a planning point of view, I broke the system down into a bunch of different components. So, first did the initial questionnaire go out? Now we're waiting for the initial questionnaire to come back. Then the next thing was initial planning meeting. Has that been, where are we on that? Then the next thing would be, retainer pending. Next would be initial drafts pending. Next would be reviewed by the client. Next would be, et cetera. And so we broke it down into a bunch of components. And but I didn't find that Outlook worked that well. And so I was searching for a different methodology or software basically to use for tasks, keeping track of a file. And I see you bring up Slack. I don't know if there's Monday.com, perfect. So this is what I use. And you create your own set of components, or stages is the way we have them. And then you just move, how I do it is I actually have the clients in here and I just move them from one to the next. So, as soon as I've met with the client for the first time, they go into retainer pending. Then as soon as I get the retainer, they go into, initial drafts pending. Then they go to drafts sent, pending review. Then they go into corrections to be made. Then they go into, et cetera. And just keeping track of who's responsible for different things and what's outstanding. So if you click, for example, in Monday.com, and you can open up that pane, and you can add a checklist, which is what I use all the time here. And I just have checklists for each client basically. And then I say, okay, we've sent the drafts out. Now what are we waiting for? Oh, review by the trust company, or I need insurance information or whatever else. And then you can just sort of track it right through to the very end. Will signed, bill went out, and just drag and drop. And so that's sort of how I do it. I'd show you, except that I have actual clients in there. So I don't think I could.
So that's why I put up mine Monday.com, because it's a little different, because this is I did this quickly this morning, but this isn't my solicitor's one, but this is my contentious litigation one, and this is just a classic example of a will challenge, but it's the same idea. And it allows me, I go into my initial contact, I've got the clerk who I've assigned that to. Actually, you can identify the person, you can put the urgency and timelines, and then you can put date completed. You can add all sorts of other tools to this. I mean, the problem with all these tools is that they can be, you can spend hours doing all sorts of, bizarre things that may or may not be relevant to your particular situation. But you've got easy to start a Zoom call from here with the clients, and you would put, or your team, I mean, and you can identify who's in your team in the top right-hand corner. So anyway, this is just one program, and I'm not, we get nothing out of this. Obviously, Monday.com doesn't know who we are, but the point is, this is a tried and tested program that's out there. It's sort of like the Outlook out there now in terms of the marketplace. So we just thought we'd put it forward and let people see as an opportunity. Before we come off that, Suzana, did you want to talk about anything about the Monday.com tool that we use?
I just think it's a really good way for us to be able to be interactive with our team as well. So there's opportunities for everyone to see where everyone is on the same page, what needs to be done. And it's a good way to keep on track and ultimately to make sure that we're not missing something, because that's the biggest concern we always have from, a file management perspective, is that we don't miss something that's very crucial.
Absolutely.
And just to jump in, Suzana, that's so useful. It's funny, not funny, but it's so interesting how you can use this differently. So you use it on a per client basis with the steps, and on a solicitor's will planning side. So for that's for your litigation stuff. Just to demonstrate, just from the solicitor side, how I use it in the reverse way. So maybe I could just share my screen for a second.
Okay, do I have to get out of mine, presumably?
Well, let's just try. Hang on.
I'm going to stop.
Okay, and now I'm going to share. And if I can figure out how to do that. Sorry, maybe I can't. But it's, hang on one second, sorry.
Yeah, no, as you're getting it up, I mean, the thing that we've found is that we've got to get ahead of this problem of managing clients and our teams remotely. And as I say, it's the horse out of the barn. So if it's out of the barn, let's use this time to be testing this stuff, because truthfully, clients are more patient right now with us doing remote tools. They're not going to be as patient when we're out of COVID, and they're going to expect us to be, pretty adept. And so that's why we've sort of, since the day one from COVID, and we all started to realize, okay, Horizon we use, but remote working is one part of it, but we have to take it that next stage. And what does that mean? That means how are we going to manage clients in a remote situation? I think it's going to be harder to get clients in our physical offices forever. I'm not saying it's going to end, but it's going to be harder. There's going to be many more clients who are just going to say, hey, I can do this remotely. So go ahead, Jordy, you've got yours up.
Is my screen shown? Yeah, so this just gives you an example of how I've set up the workflow for a will file, and just moving people, from the initial planning pending to the memo to the, retainer pending, info pending, et cetera, and just move throughout. Then you can sort of you can keep track of when due dates and all those kinds of things, and who's assigned, and just I just found it to be, and it's a recent development for me. I just found it to be a useful way of keeping track of things.
Yeah, and I don't think it's actually any different than our steps. We just have identified them as steps, but we're doing the same thing. Initial planning meeting, when we're talking initial intake, initial memo, what do we do? And then, so that's great. And I think that tool, the other part of the tool, I just want to screen share. Can you come out of yours and then let me?
I did. Yep.
Thanks. I just want to go back into my screen share, because the other part of the tool that is so crucial is that it's, what is it going to link to? What other tools can you use within the programs? And for example, LexisNexis has a great product in respect of their on the litigation side for sure, but also on the solicitor side. And they have precedents. And so what we've done is we PDF some of those precedents right into our steps. And you can see for us, this is the contentious one. It goes right through to discoveries and all of that sort of stuff. But I'll just give you a quick example within the program itself. So the initial contact, once I hit it, I I can get into it, and then in my information box, there's a complete the intake questionnaire. Well, I can link to that intake questionnaire, and it comes right up. And so I'm sitting there in Monday.com with the actual document, which is not doing it right now because, of course, it never works when you actually want to show it. But you can see the kind of tool that gives you. So it's these programs. It's a start with the technology, the core driver, and then see what can be worked within it. The other part of this, and we started with that, was Slack, and by no means does it solve everything, but Slack is another tool that we're using. That's just their webpage, just so you can know what we're talking about. This is an internal email management tool that allows you to work within your team, and I use it for both solicitors and contentious matters because it allows me to be talking between my team members and not clogging up my inbox and Outlook. So I can try to focus my Outlook inbox for client-based and interchange with lawyers and so on. But I'm not having to clog it with my inbox with. So if I want to say quickly, hey, listen, we're missing that. Can you do a sub search on that house to make sure it's not joint tenancy and that it's actually tenancy in common? I flip an email to an internal email through Slack to my assistant. She does the search on Terranet, sends it back to me in Slack, says it's all clear, and attaches the actual search. That exchange, of course, can be done by inbox through Outlook, of course, but this allows us to keep it internal. And at the very end, when the file's done, you can actually export all of your Slack for that particular client. So I will then put that into my document management. I'll take the exchange that's happened on that file and put it in my document management to help me protect myself at the back end, so that someone says, hey, you didn't do a title search. Well, actually we did, and actually we did report that out. So that's another tool that you could think about. The last point, before I come off that, Suzana, did you have anything, and Jordy, do you want to talk about your experience with Slack? Why don't we talk with you, Suzana?
Well, we initially found that Slack was most helpful because when we started the transition to remote working, we as lawyers were certainly all set up and able to work from home, but we had to accommodate the staff for that purpose as well. And one of the things that, as you can imagine, the staff don't have firm phones, and so they've got their own individual phones, and they can't access the firm emails. And so we weren't able to keep in touch with them immediately, in terms of, don't come into the office, we're going to work remotely. And those kinds of exchanges couldn't be had because the staff didn't have access to their emails. So by setting up Slack, everyone could put it on their personal phones, their personal computers, and had the opportunity to communicate when we couldn't do it through the traditional email fashion. So it was very helpful for us initially. And now it's become very adopted by, I'd say, everyone in the firm, because it is a very easy way to get someone's attention and not be caught with the clutter of an inbox through traditional email purposes.
Jordy, you use Slack as well?
Yeah, it's great for just quick communication, sending documents to one another. Very, very efficient way of inter-firm communication.
Well, before we get into some stand-up stuff, I just wanted to add one last thing. This is a daily blog I get every day, Seth Godin, and he is the biggest blogger in the world, probably, in the sense of the most popular. And I thought today's was a great one. In many situations, a leaky roof is worse than no roof at all. If there's no roof, we're not surprised or disappointed if we get hit with some raindrops. But if a roof leaks, if a roof that leaks has raised expectations and then failed to meet them, promising us a roof, then breaking that promise might be worse than no roof at all. Great client management comment today. So anyway, he's a great, if you're interested, they're always short blogs. You can see well, that's a bit longer, but they're really punchy, and he's a good first morning read. Okay, so let's go back off my screen, because Jordy will be going to your screen shortly, just to give you a heads up. But let me just get out of there. Sorry. The thing I wanted to sort of continue on a discussion with is avoiding mistakes. And one of the things that we started with, of course, is avoiding mistakes. Is a big part of that is client management, and the client management that comes from efficient technology and so forth that we've just discussed in that regard. But we've talked a little bit about, we've talked a lot about, witnessing and execution, and I don't want to get into that anymore today. But one of the things that we're doing, certainly from our office, and making clear when we come out of COVID, is we're saying to our clients, you got to come back and re-sign. And for most of my clients, certainly if it's just a re-signing, I'm not going to charge. Jordy, what about you? What are you doing on the execution? Notwithstanding the efforts we're taking, the enormous efforts we're taking to execution, what are you doing on that front as we come out of this?
Yeah, I'm going to recommend that they do come back to sign, especially if we've done a counterpart, just to make things a little bit simpler and shorter. And so, yeah, I would, that's what I'm doing. And I'm not necessarily planning on charging again, but we'll see. I think we'll see.
Yeah, it might open it up to further discussion. Suzana, did you have anything on the re-execution?
No, I just think that that's probably going to be a counsel of caution. Everyone's going to suggest it, and then it's ultimately be up to the clients as to whether or not they intend to do so.
All right. So, Jordy and Suzana, one of the, and Jordy, you last week, I think, brought up that great pie chart that LawPro has put out in terms of where problems arise, and that helps us identify where we need to be vigilant in our practice. But one of the things is the failure to document the will drafting instructions. I know, Suzana, on the litigation side, you have a strong view about the nature and extent of notes, and I'd like to hear your thoughts on that. And then Jordy, on your side, knowing that there are people like Suzana out there scrutinizing that, what are some of the tools and what are some of the steps you're taking to make sure that you don't have a claim surrounding a failure to properly document the will instructions? Suzana, do you want to start that?
Sure, I think it, and I know that with the change in circumstances now, the technology has taken a much more prominent role in our intake in some cases, but it really still remains so important that we're documenting instructions from clients, that our notes are fulsome, and that we're really using those notes then and relying on them for the purposes of the ultimate drafting of the will, because we don't want to just rely on memory. And it's so easy with a litigator to look at a solicitor's file with the benefit of hindsight and say, well, you didn't do this or you didn't do that. And so that's why we've always really relied quite heavily on checklists to make sure that things are being done by as a matter of rote, actually, so that we can say, yes, we always do this, and therefore we would have asked it, and if it was an issue, we would have documented it, or document the fact that it wasn't an issue. So I think that is not changed in this new environment. We can have tools to enhance the ability to do that, but we still have, the good old-fashioned importance of actual handwritten notes.
Jordy, so what are you doing then on the note-taking and also on the saving of the notes?
Yeah, I think just a couple of comments on that. This idea that, and historically it's been successful, I think, and Suzana and Ian, you can comment on this, but this idea that, yes, I don't have notes of that point, but I always do it this way. I always do it that way. Now with technology, I think we're going to see an increase in concerns where there's no an actual record of what happened. I think certainly, historically we didn't audio tape and videotape and all of that stuff for a bunch of reasons. But I think, I've always been a believer that in a will challenge, a court hearing the testators say why they're doing something is as powerful as it can be, and way more powerful, in my view, than a lawyer saying, this is what she told me. Now it is flawed. It exposes it to a minute investigation of every aspect of the discussion, for sure. But I wonder if we're not going to see an increase in that, in the use of recordings to document that stuff. If you're, so I typically do, and certainly with Zoom, we're doing it almost by rote. But as far as keeping notes, and tracking instructions. Let's just maybe talk about that point, because that's where so many errors occur. The notes say one thing, and Suzanne, and you can talk to this, I'm sure. The notes say one thing and the draft says something else. And I mean, that is about as damning a situation as you can get, but it's not uncommon, right, Suzana?
Absolutely not. And then what you're left with is just the recollection of the lawyer. And as honest and truthful as it may be, it's still going to always be judged with, a sense of suspicion, and the fact that, someone's going to always be in personal protection mode when you're in these difficult situations and someone's holding you unfairly unaccountable for that, or sort of accountable for it. So I think, it is a hard conversation and it's going to be a hard one to defend if that happens. And so we try to build in as many protections as we can to make sure that we can avoid that.
And what I historically used was a, will summary form, because, often you guys are left with looking at a bunch of scribbles, and they're not necessarily, they're code in many cases. What does IPS mean? Oh, issue per circuits. Okay. So you don't, you need translation, and it's a rare occasion, I would expect, that the notes are as fulsome as you would, as counsel defending them would like, right?
Absolutely.
Yeah. So yeah.
Go ahead. So Jordy, what have you done to help protect that? We've got recording. Are there any other aspects of your day-to-day practice that you've changed to help protect that?
So I obviously, and you guys know, I use software to do that, right? So there can't be necessarily disconnect between. Now, there's no disconnect between what is in the software and the draft that's produced. So whatever instructions were given, and maybe I'll just flip that on and just show that, whatever instructions were given, are going to appear. So if the instructions are cash to Haley Dunphy of $500,000, well, that's what's going to get generated. That is going to be the document that's generated. So you can be assured that whatever the instructions are, they're reflected in the document. So that gets rid of a huge number of issues. And of course, the client has seen it, has checked it, has reviewed it. And so there's not going to be any kind of disconnect there between what the client sees in a whole bunch of spots. So, what the client sees, not only when you're planning the will and doing it live with the client, oh, I want to give, each of my grandchildren, 10 grand or whatever it is, or 100 grand. So the client can see that part. But not only that, they can also see it when they get the graphic representation of the will plan. So in that sense, they're checking it and checking it and checking it and can refer back to it. But the key here really is that there's no disconnect between what the instructions are and what the document that is created is. That does still create another issue, which I'd like to just address after, if you don't mind.
Well, why don't we do it while you're on?
Okay. So, so I think I've talked about this. Let me just stop sharing for a second so I don't inadvertently disclose when I switch screens. But the one very common situation is where instructions change from one draft to another draft. And if you don't update that in the software, and you should, I mean, in my case I do, but or in anywhere, however you're generating it, documenting those changes are so important. And that's where you can also, Suzanne, I'm sure you see these cases where, one draft, sure, everybody was getting an equal amount. And now in the second draft, there's, one kid's getting the loans forgiven, right? Let's take that situation. And there's no notes and no explanation of how that change occurred. That I think is a crucial gap if you're not careful in documenting the changes. And so just
the reasons for the changes too.
Absolutely, right. Keep that. That's the most important, really. in some sense.
Like just as you're looking at your screen, Suzana, let's talk a little bit about documenting, not just the act of documenting, but the rationale.
Yeah, and I think that, the difficulty with these situations, we all know, is that, at the end of the day, when we're being held accountable, it's like this expectation of perfection. But the reality is no one is perfect. And when we're doing wills at such a reduced, cost base, just by virtue of the fact that the marketplace isn't allowing us to charge the full value of these documents, it makes it really difficult to make sure that you're constantly properly documenting everything. But we definitely do, when we're given these instructions, we want to understand the rationale for the changes. We want to document that, because then we can defend the fact that there was a reason for this, that it wasn't just an oversight, and hopefully, either convince the beneficiaries who are challenging the will that this is in fact what mom or dad wanted when they made the change, or convince a judge that this isn't definitely what was the intention of the testator. And we can only do our best, and we recognize that. And there is no perfect way to bulletproof a will, but the notes is definitely the first starting point, that's for sure.
And then Jordy, before we come to your next screen, I think one of the things that when I'm getting connected with, when I'm going to, approaching a will in a contentious situation, that, I always wonder is that all you had to do was ask why. You can document, you can intake, but it's the probe and verify. And why are you doing that? Like, what, even to engage conversation, to test capacity, or do it, just to make sure they're not mistaken. Or, if they say, I want to give to cancer, and you say, well, what part of cancer do you want to give to? There's about, there's different versions of that kind of gifting. Or you're kicking your kid out of the will. Well, why? And then you document that rationale. The rationale is what carries the day at the trial. And so I'm a big fan of just pushing back and saying, well, no problem. It's, it's a free and democratic society, but let's have an explanation. So Jordy, let's go to your next point.
Yeah, I'm not 100% sure if I've ever shared this with people, but this came out of, like most changes in my process, it came out of a case that I was involved in, where there was some dispute as to how changes occurred to a draft. And of course, technology wasn't used in that case. But so this is something that I have I use with my client every time I'm reviewing a draft with the client. And it's a manual, sort of a handwritten thing. And I just keep track of, the topics that I've, talked about, or if I've just had my usual discussion, then I just, click on, say, check mark or whatever, but then it tracks the change. So if I am making a change to the trust for the home, then I'll write the change in here. Now I also record, so I have that as well, but this is a great reference. And so typically I'd have two of these in my file, because I'd have one in my client review, the initial review of the draft, and then one in the signing meeting, where I typically just run through things and say, okay, here are the changes, here's what we've done, let's just run through it one more time. And it's comforting to know, okay, this is when I met with them, this is how we did the discussion, here's how much we spent, and who was there, and just easy reference back to how changes emerged from one draft to another. People always ask, what's BUCA? Beneficiaries under a certain age. So I just talked to them about these remote descendants. And what's CBO? It's children born out of wedlock. But just so I have a record. And notes, I always found taking notes very difficult in a client meeting, because you're trying to focus on what they're saying. So you're taking down part of it. There's no record of what the question was necessarily. I find it very difficult. I always did. It's important, crucial to keep notes in some form, some record of the information. But so anyway, that's
a great. I thought that was Cuba you were talking about, but now I got it.
No.
All right. So just on that point, Jordy, because I know, and then Suzana, you can give us some of your practical experience where this has arisen. For residue clauses and how best to divide residue. having divisions of residue in the percentage basis or in parts. Jordy, what's your practice and why? And Suzana, tell us a little bit about some of your experiences in that regard on a contentious site. So Jordy, what do we go with, parts? Do we go with percentages?
So the problem with percentages in a residue gift is if the person who's getting that percentage is not around, there's a lapse and a partial intestacy for that portion. And so to avoid that possibility, and you can, there's always, I guess, a possibility if you use percentage that no one will be around or that there's a lapse of that gift. And so we don't use percentages. I don't use percentages when dealing with drafting of a residue gift. Now, that being said, clients do think of percentages. So just as an example, when clients are thinking about dividing their estate, they are not thinking 4 parts, most clients aren't thinking 4 parts to this person, 3 parts to that person. Instead, what they're thinking is, I'm going to give 25% to this person, 25% to that person. And if they're not alive, when I want everybody to move up, basically. So that is a parts, what you're doing there in the residue clause is you're creating parts because, and what we call a floating share theory. So you create only as many shares of the estate or parts of the estate that you need based on who's alive. And I'm going to, if you give me a couple of minutes, call up something that demonstrates that. But in that way, and that works perfectly if what the client wants is, if nobody's around to take that percentage, everyone else just splits it pro rata. That's how floating shares work. And so you'll see, for estate, for example, we reference back to the percentage amount in the sense that we say, 25 parts to John, create 25 parts if John's alive. And if John's not alive, we don't create those 25 parts. So basically, we're working out of 75 parts. So by definition, everybody moves up. And I can demonstrate that a little bit, but maybe Suzana can talk about how, the cases that she's seen, because we see these percentages all the time.
Well, the biggest mistake is, of course, when the percentages don't add up to 100. And it sounds so basic and so simple, but I've seen many, many cases where that just doesn't, because we haven't built in the, what if scenario. If one of the individuals who's intended to get a percentage doesn't survive the deceased, as Jordy's suggesting. So that's a really big concern. And I think the, following a logic tree or a flow through of every possible scenario is so key there, because then, you yourself are looking at the possible, gift over situations, and your client is also exploring that, and you're getting their instructions on what would happen in these scenarios where someone isn't necessarily around to get it. And it also avoids a situation where perhaps you've given away more than 100% of the residue of the estate. And I've seen those kinds of situations as well. So I think we really want to make sure that we're careful, that we're documenting and anticipating all of these different situations, but that we follow through every potential situation so that we can avoid these kinds of errors.
And
why don't you go ahead, Jordy?
Yeah, I mean, that's, how many cases have we seen where it doesn't add up to 100 because somebody's changed one, and this goes back to your same point, Suzana, about changes from draft to draft, where somebody said, oh, by the way, I want 30% to go to that person. They were getting 25. Oh, so you're not necessarily thinking, you do it in a rush, you don't change, somebody doesn't change, and all of a sudden you have 105%.
Exactly.
And right. And so that's why, there's really not a great reason to use percentages in a will, in a residue clause. Now you can give percent if like there are certain places where you could use it, but not when you're dividing up, in my view, not when you're dividing up the residue. And so I'm just going to demonstrate again how software can avoid that, because I'm just going to share my screen if I could. And so here's just a simple situation where, the software here makes sure that we can't give more than 100%. And if we didn't give, if, for example, we were giving away less than 100%, we'd know about it. So, if this was only 5%, when the client's looking at it, it warns us. Just to give a demonstration of the floating shares, because actually, I've had a lot of questions about, when we show our software and our template, where they say, oh, I use percentages, and I'm like, well, here's why I don't think you should do it. But just as an example, here is, let me just show you. So here's how we do floating shares. You're dividing the residue into as many equal parts. So we don't know how many parts we're going to have, because it's all going to depend on who's alive. If everybody's alive, we have 15 parts going to Alex, we have 15 parts going to Jay, and we've got 70 parts to Joe. But for example, if Alex wasn't alive, we would just delete those 15 parts, and now all we have is a total of 85 parts. But by definition, 15 out of 85, everyone's moved up pro rata, and that's really how floating shares work. And yes, you could actually have less than 100 parts, right? You don't have to have 100 parts. You need 100%, but you don't need 100 parts.
That's right.
Yeah. Anyway, that's that.
Well, that's a really important, and that's a great solution. The floating parts is the answer. Okay, so in the last part of this seminar, I just want to try to talk a little bit about codicils, Jordy, and maybe you, as I'm centering this on, you can just jump on the checklist that you have in regard to the codicil preparation, but if you have one, but it doesn't matter. What I want to talk about is this: errors involving codicils. Now, it is especially in COVID times, it is a tool that, quite frankly, is being used by me more than I ever did because of the simplicity of it. And for example, if I'm just changing executors, it creates a little bit of a problem, but it's a solution that is much easier than doing the whole new will. And so while until COVID, I was a bit of a naysayer of codicils, I've been doing it more than don't listen to anything I've ever said about them. First of all, of course, attaching the codicil to the wrong will can occur. Duplicating a paragraph in the will that the codicil was supposed to remove. Accidentally deleting a defined term from the will. Replacing or deleting the wrong paragraph in a will. Those are all things that are easily done when you're errors that are identifiable with codicils. And certainly, Suzana, you've litigated all of those examples, I know yourself. So, Jordy, why don't we start with you, and then Suzana, maybe you can give some thought and some comment on the use of codicils, but also on some of the errors and how to avoid them. So, Jordy, what are your thoughts?
So, a couple of points about codicils. Obviously, now with word processing, historically we didn't use them as often. It was easier just to reproduce a brand new will. And much cleaner. But a point that just comes to mind about codicils is sometimes you think that a simple change is occurring, but it's actually having a ripple effect on a whole bunch of other things. So for example, a client has a will with no charitable gifts in it, and all of a sudden they want to make a gift to charity. So you make a gift to charity, but you can easily forget to add the charity clauses that you would normally put into a will about who can receive it, how discharge is going to happen, what happens if they change the name, and those kinds of things. So there's so many things interconnected often. That's why codicils, I think, are quite dangerous. Now, changing an executor might not be a problem, but sometimes, and we're talking right now about single wills, right? Single wills, codicils, not as big an issue for sure if you're changing something small. The other part of things is I like to really number my paragraphs for that reason as well. So almost every paragraph is numbered, and so I can easily in a codicil, or for example, delete this paragraph or add to the next paragraph. And I can refer to it. I've seen so many wills now that remarkably don't have any paragraph numbering. And so, I would certainly encourage that, especially if you're going to contemplate down the road some sort of codicil.
Great point on the numbering, Jordy. For sure, it's deadly in court too when you're trying to go through an interpretation problem or a repair or rectification. Suzana, did you have any thoughts on codicils?
Just the easiest one, again, an illustration of making sure that we're referring to the proper dated will. It's hard enough that we're trying to make sure that we're cross-referencing to proper paragraph numbers, but I've seen many illustrations where it's so clearly referring to we know what will it's referring to, but it's dated improperly. And that just, adds a layer of complexity for no reason. Also always wanting to make sure that when I'm looking at a codicil, reading it together with the will, that they work together, that there aren't any inadvertent discrepancies between the two, like perhaps some kind of a revocation that's not intended, but that comes about as a consequence of the codicil, or if there's terminology that is suddenly introduced into a codicil that isn't incorporated into the will, it may just make it more difficult to read those two documents together, even though everyone knows what was probably intended. If it's not necessarily clear, there's always an opportunity for someone to challenge it on that basis.
Just trying to find our information about holograph codicils. Those are ones. So just to back up, of course, you can make a holograph codicil to a formal will. That is valid. It doesn't have to be a formal codicil. That is two witnesses. It can be a holograph. And so that's where we're seeing so much of that, where, excuse me, if you've got a client doesn't have Zoom, you can't use the counterpart situation, you're left with just a holograph option. A holograph codicil is an option there. And so, there are, and we can certainly try to find our link about, what you want to do in a holograph document, which is it's got to be entirely in the handwriting of the testator and signed by them. And again, referencing what will we're talking about in, with respect to the codicil. So I'll see what I can do about tracking that down if you give me a second here.
Yeah, no, for sure. And I think that's the key is giving options. We just have so many, we've always had these options, but we have to be thinking about creative options now when we don't have the luxury of direct contact with our clients. And that's what a lot of our resources in COVID on our webpage has been trying to do. And that is just give people alternatives. Who would have thought to do a holograph codicil pre-COVID? Rare. Couldn't count on one hand how many times I've even crossed my mind to do it, because you had the physical access to the client, whether you had to go see the client or they came to you. So you're so right, Jordy. This is another tool that needs to be considered. So I see you're sharing the screen on this.
Yeah, just this is sort of a suggestion for how you could make a holograph codicil, directions to a potential testator, so and we've seen it in emergency situations. Somebody's separated from their spouse and they want to make a change, and they can't just revoke the will, or that wouldn't result in the spouse getting everything by intestacy. So we have to do a codicil, and so this is kind of a sample. Obviously you put in what you want to put in, but that's what you want to do as far as a holograph codicil goes.
That's great. Okay, it's Sydney. I know our host and our associate, Sydney Asmars. Can you, I've just found there was a question that was sent and I can't call it up. Maybe you could find it and jump on and just read out what the question is. And before you do that, I'll just note on the chat line, a great point is we were going through the uses of technology tools, and Windows 365 does a lot of what Slack does at no extra charge. So that's another useful tool if you're using Windows 365 to look at. We adopted Slack, but as these things are, they tend to be an added cost. So, Sydney, did you, by any chance, I'm way behind on this, and know the question that we had?
Are you referring to the question that was emailed in yesterday?
Please.
Yeah, so I can read that out. So the participants looking in exploring how everyone's conducting their power of attorney signatures. They normally hand out 3 signed copies of each of the power of attorneys, but if it's being done in counterparts, then that does double the paper for everything. They're also looking for some comment on whether additional fees will be charged for the extra time or work, but I think we did address that earlier in the webinar today. And yeah, so looking for some comments on how people are conducting the signatures of powers of attorney when done in counterpart, and if extra fees will be charged.
Thanks, Sydney. That's great help. Sorry, didn't have it readily available. Jordy, why don't we start with you on some of that practice point?
Yeah, so I've reduced the number of signings I'm doing as far as how many copies of a power of attorney. So yeah, I used to do 2. Now typically I'm just doing 1, especially if it's in counterpart. So that's just what I'm doing, but it is a lot of paper. There's a lot of paper involved, especially if the witnesses are in different spots. So, I think, again, if this is a stopgap measure, let's get these powers of attorney in place. If it's 1 copy, that's okay. And if it's the other way of looking at it is, look, it's just paper, so who cares how long it is, right? But I typically have reduced the number of powers of attorney that I'm signing.
And Suzana, do you have any thoughts on this? Because as we come into a contentious situation, of course, more paper is not necessarily better. It allows for mistakes.
Yeah, and that's just the key point. I think, there's always going to be an opportunity for someone to try to attack it on the basis that something was missed or wasn't done properly. And with 3 copies of the same document, there's 3 opportunities for things to go wrong. So, having said that, we're just doing the best that we can in these circumstances. And I think, if these things do come to a challenge, that at some point, hopefully the judges are going to be remembering what it was like to practice law in this environment.
I don't have a lot of faith in that. They tend to, once they're appointed, forget they were lawyers.
Not all of them.
I'm kidding. Okay, so absolutely right. And we've already had some demonstration of some sensible decisions that have come out, COVID related, where the courts are saying, first of all, get over yourselves. It's a different world. And secondly, I know Justice Myers made a great decision about the use of technology and the importance of just in a litigated environment anyway, people have to get used to it. And so I agree with you 100%. I think the decisions that are going to come out of post-COVID are going to be, the reality will be fresh in the mind of these judges, and I think there'll be some accommodation accordingly. All right, well, look, it's almost near the end, and I've checked our chat line and covered what we wanted to cover today. Next week, we've got another action-packed list of topics to discuss, including failed gifts and gift overs, and how we deal with gift over clauses and executorship. So thanks so much, Suzana. Thanks so much, Jordan, for another week. Wish everyone a great weekend, and we will see you all next week at the same bat time. All right. Thanks again.
Thanks, everybody.
Thanks, everybody. Bye-bye. Be safe.
Bye-bye now.